You are here in the small claims division of 3B District Court. The rules are relaxed, they are not as strict as they are in the general division of the court. We don't strictly follow the rules of evidence or procedure. Neither party is allowed to have an attorney in small claims court. Raise your right hand. You all swear or affirm that any testimony you are about to give in this matter will be true, to the best of your knowledge and belief. There is no formal record in small claims court, and there is no appeal. Any decision made here is final. Either party has the right to remove the matter from the small claims division to the regular division of the court, where you could sue for up to $25,000. But you would have to tell me before we begin. Once we begin here, any decision made here is final. Raise your right hand. Do you all swear or affirm that any testimony you are about to give in this matter will be true, to the best of your knowledge and belief? To the best of your knowledge and belief. To the best of your knowledge and belief. The best of your knowledge and belief.
Mr. Gintz, can you hear me?
Just asked him to unmute.
Looks like you're talking, but we cannot hear you.
Hello, can you hear me now?
Okay, I can.
This is X Faldover at LawNerdsUnite. Thankfully, it's been so nice. We had a long holiday weekend, and it was tough sledding getting material, but now there's just tons of it.
Are you Larry Gintz?
Yes, sir, I am.
All right, and is Terry Moore here?
Yes, sir.
All right, Mr. Moore, if you could adjust your device just a little, all I can see is just a corner of your forehead.
Okay.
That's better, thank you. Okay, I'd ask you both to raise your right hands, please. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hands down. This is a small claims case. I'll hear from Mr. Gintz first. And I ask that Mr. Moore, you not interrupt him. Then I'll hear from Mr. Moore. And Mr. Gintz, I'd ask you not interrupt him. I may have some questions, and I'll go ahead and make a decision. So, Mr. Gintz, if you'd state the basis of your claim, please.
All right, the basis of my claim is that I did 3 different driveways, which consisted of one job for Terry Moore. And afterwards, he wrote me a check and then stopped payment on the check. Prior to giving me the check, he was complaining about the price, and I gave him an estimate, and the estimate ended up being $400 a little low. The actual cost was $400 higher than the estimate. And he balked at that for some time, and I got tired of it. It was the end of the day. I wanted to go home, be done with it. And I said, just go ahead and give me what the estimate was, and let's be done with this. And so he wrote me out a check. And a couple of days later, he stopped payment on the check, saying there was the statement on the, the comment on the statement I got that there was unresolved issues. And
Right. What was the amount of the check that he wrote you?
$3,100.
All right. And when you say you did 3 driveways, what do you mean? Was this snow plowing? Was it resurfacing? What was it?
Basically resurfaced one of them and built a new one at one address, and then rebuilt one at a third address.
Okay, and what was the estimate? Was the estimate you gave him $3,100?
Yes, sir.
All right. Now the lawsuit that you filed was for $4,470.23. What's the difference between those two numbers?
Also, there's an additional $30 on there for the sheriff's
Right. Okay.
delivery.
But putting to that side, how did you get from 3,100 to 4,400?
Okay. I have it on paper here. I wrote it all down.
Wow, that strikes me as really inexpensive. I mean, I can't tell because I can't see the size of the driveway, so which is the big factor here. But just when he says he did all that work on 3 driveways for $3,100, it seems incredibly inexpensive to me.
After he stopped payment on the check, my bank account bounced, and I had to make 2 trips to the bank to get it squared away, which was 56 miles total. I added up the mileage, and I made 3 trips to his McCoy Road address rental that I worked at, and he was supposed to meet me there at all 3 times, in which I got there and waited, and finally he would answer his phone and said he couldn't make it, and so on and so forth, and ended up not making it at all. So I charged him for those miles, which was a total of 96 miles. I also made a trip to his house to try to get this to work out, and he wouldn't converse with me face to face. He was in the other room, and I was standing outside the door, and the conversation went back and forth, and it was basically a no win for either.
I don't need to get into details of it. Just so I understand it, you're saying the check that bounced was for $3,100, and that was also the amount of the estimate. Is that correct?
The estimate that is the estimate. Yes.
Okay. And was that the amount of the check that bounced as well?
Yes, sir.
Okay. All right. Thank you. All right, Mr. Moore, what did you want to say?
Well, part of what Mr. Gintz said is correct, except he didn't say that when we discussed him doing the driveways, I told him that I wanted it crowned so the water would roll off each side, and there was a big bird bath, a 10-foot round mud puddle in the middle of one of the driveways. I said, I don't want a bird bath in this driveway. I said, I want it crowned and the bird bath gone. And I did stop payment on the check because the person who rented the house from me, it was a rental home of mine. This is the one at McCoy Road. The person that rented it contacted me and asked me if I gave Mr. Gintz all these things that were at that house. And I said, I didn't give him anything. He said, well, he took a toolbox. He took a gas grill. I had 2 big, thick pieces of lumber there, one for a coffee table and one for a mantel. They were 3 inches thick, 2 foot wide, and 5 feet long, and they were cut out of one piece of wood out of an oak tree. And he took both of those. Those are items that I know he took. I'm also missing a 6-foot level. I don't know if he took that or not, but it's not there any longer, and I haven't found it anywhere. So that's missing in action. So when I stopped payment on the check, I knew I would hear from him, and then I was going to tell him I want all the things that he took from my house to be returned, and then he would get paid. Well, in that same time period, it rained, and when it rained, suddenly I had another big bird bath in the middle of the driveway. And I told him, I want that driveway fixed where that bird bath is not there. You can go over
Damn it, both of these guys make sense.
there and look at it and see. It's got this big mud
If that happened, return the crap and pay him. Next.
puddle in the middle of it, just like it did before you supposedly fixed it and resurfaced it. And he said he's not fixing the driveway until I pay him. And I said, well, I'm not paying you until you finish the job and get the bird bath and crown that driveway.
I see the problem here. We've got us a Mexican standoff involving no Mexicans whatsoever.
Like we discussed. And that's how it stopped right there.
Was this the driveway that wasn't crowned, that had the mud puddle in it? Was that, well, are there 3 driveways in question?
Yes, sir.
And was there a problem? Was this just one of them that had this problem, or all 3 of them, or what are you saying?
Just one of them had the big problem. I noticed on one of the other driveways, there's 2 mud puddles in that driveway now also, but I'm not even discussing that one at this point. I'm not satisfied with it, but I can fix that with, a couple of wheelbarrows of gravel and hopefully fill those 2 mud puddles there in one of the other driveways. In the third driveway, I haven't really seen. It's out to Waters, and I don't get out there that often to see it. So I guess that one's okay. But the one in question, the one that is the one that had the 10-foot mud puddle in the middle of it, and it still does. And I've got photos of that on my phone also.
All right, Mr. Gens, the items that Mr. Moore said you took, a toolbox, a gas grill, and some lumber, did you take them?
Yes, sir, I did, and I can explain. The toolbox is a aluminum toolbox that goes in the back of a pickup truck, and it was damaged. And it was laying in the junk in the driveway behind a trailer that was full of junk that he had been removing out of the house and throwing stuff away. Now, I picked up the toolbox to move it out of the way because he was supposed to move the trailer out of the driveway so I could do the job, and he didn't do that. So when I got there, I unhooked from my trailer, hooked my truck up to that trailer, moved it out of the way, moved all the junk out of the way. And then when I got done, he wanted the trailer put back in the driveway. So I picked up the toolbox because he told me everything that he had in the trailer, he was taking it to the dump. And he was complaining about how the people that lived there left the place a mess, and they left a bunch of trash, which I've got pictures of all the trash and the trailer and the items that I took. The second item I took was not a gas grill. It was a gas tank off of a grill, a little propane tank. And that was on a grill that was smashed. There was 2 of them that were by the garage there. And I figured he's throwing that stuff out. I needed a tank, so I took the tank. The boards, those boards.
Damn it, this is just reasonable all around. It really is. Like, I understand why the guy's mad that stuff was taken, but I understand why the guy took it. It's weird. Like, they keep saying things, and I'm like, all right, this is dramatic hamster. And then it goes to the other guy, and I'm like, oh, okay, that makes sense. This is totally fixable. I don't know what happens. We'll see.
One of them was laying there in the driveway. The other one was out by the road, and his tenant, his name is Gabe, he went out to the road there and grabbed the board and brought it back because there was another board there, and he said it was just like that one. So I said, well, I'll take it, and threw it on the trailer. Well, I brought all the stuff back when the check stopped. When he stopped.
Fair enough. Like, I agree. You can't just take it without saying, but it sounds like he brought it back, and I can kind of see what his thought process was.
Payment on the check, and I called him, and he mentioned this, and I says, I thought you was throwing all that stuff out. It was a serious misunderstanding. I'll be back with it right now. I'll bring it back right now, and I'll meet you there in an hour. And then you can pay me for doing the job. And he said, okay. And so I loaded the stuff up. I took it back to the McCoy Road address. I took pictures of it on my trailer. And then I took pictures of it sitting on the ground off of my trailer after I dropped the stuff off. He didn't show up. And when I called, he didn't.
My God, these old boys are just reasonable, right down to taking pictures of it.
Answer and didn't answer. I went home.
You returned a toolbox, a gas grill, and a lumber. Is that what you're saying?
There was no gas grill. It was just a gas tank.
I'm sorry. Toolbox, gas tank, and lumber. You returned those?
Yes, sir. I took him
And
back
did
to we talked.
Hold on. Did you take a 6-foot level?
I never saw a level. I didn't take anything that I didn't think was junk, sir.
What about the rain, the mud puddle on the one driveway, the large one?
The condition on that whole ordeal is when he paid me for the job, that if there was any problems and the driveways needed to be top dressed or anything, that's what I call it, top dressed, I would come back and scrape and take care of any low spots, which anytime you do gravel work, you are going to have soft spots. And I know this. I told him if there was any problems, give me a call. I would come back and I would top dress the driveway and take care of it to his liking. And he agreed.
Okay. Did he ever ask you to come back and do it?
Yeah, after he stopped payment on the check, he was complaining. By this week had went by.
All right.
And he was saying there was a mud puddle there. Well, yeah, there probably was. I expected there to be something in one of the 3 places. I told him, I said, I don't use a laser. I do this all by eye, and I'll do the best job I can, and I'll make it right with you. But I want to be paid for what I did initially. I paid $1,200 out of pocket for 2 semi-loads of gravel.
Okay. Just limit your answer to my questions, please. So let me go back to Mr. Moore then. Mr. Moore, did he return the toolbox, the gas tank, and the lumber?
Yes, sir. Also, I have the person that he's speaking of that was at the house there, who's that house for me now. His name is Gabe, and he's sitting here with me. And he was there when Mr. Gintz took all this stuff, and he took exactly what I said.
Okay, and he's not disputing that. He said he returned it. Is that true?
He didn't. Yes, but when he returned it, he did return the gas grill along with the gas tank.
Okay, but what he took, hold on, without getting into anything more, he returned what you said he took. Is that correct?
Some of, yes.
Well, what didn't he return that he took?
Well, he did return the gas grill, but he's not even admitting that he took the gas grill.
Okay, one.
Oh, shut up. If it's returned, who cares? We're past the issue.
I understand that. I understand what you're saying, but you're saying he returned it anyway. But did he return the toolbox and the lumber?
Yes, sir.
All right. You know, I know you're not in that business. He is, but what would it take to do what he called top dressing of the one driveway?
Well, it's the puddle that I have photos of is 6 to 8 feet in circles still, and it would probably take probably to top dress it and fill the puddle and crown the driveway at least 5 yards of gravel.
All right, Mr. Gentz, have you seen that where that puddle is?
Yes, sir, I have.
And do you agree with his estimate that it would take about 5 yards of gravel?
I do not agree with his estimate.
What do you think it would take to correct it?
I just need to go over there with my tractor and my back blade, and I need to scrape a little gravel off of one side there and bring it over to the center and smooth out the side that has the hole on it, and it'll be just fine.
I guess I suspect I know the answer to this. I'll ask you both this. I'll start with you, Mr. Gentz. Is that possible to do now with the snow that's fallen?
No, it's not.
Okay, that's kind of what I thought would be the case. If it was possible, would you be willing to do it?
Absolutely. And I told him that I would come back if there's any issue.
This is some real Michigan shit going on here. Holy Toledo. I feel like I'm back at home.
I told him that right out of the gates.
I understand that. Mr. Moore, I suspect it couldn't be done now, but assuming or that we get to a time in the year when it can be done, would you be satisfied to have him come back and correct the error or the mud puddle?
Yes, but I do not agree with taking. There's not that much on the driveway now gravel. And if you want to take it from other spots to fill the mud puddle, there's just not enough material was used.
All right. And, I don't know the answer to that question. You guys may not be certain of it until you see what happens. And it couldn't happen until, I suppose, March or April, just given where we are at the seasonal now. So I can do this one of two ways. I can come up with a number, which I'm willing to do, and that's going to settle everything. And I'd say to you, Mr. Gens, you're not entitled to like mileage or things like that. And people ask for that all the time. I understand why you do, but that's not part of that's not the type of damages you can get in a contract action, which is what this is. So your maximum recovery is $3,100 plus court costs. Court costs are $100.20. I wouldn't give you $3,100 because if you wanted me to make a decision now, I will deduct something, and I don't know what. It'll be a shot in the dark. I will deduct something for the correction that on the driveway. You both have a little bit different idea, and there's no way I can know, so I'll just have to kind of take a little bit of a guess. Now, the other option is to postpone my decision on this until it can be done. That's what, another 3, 4, or 5 months down the road. So and I'm kind of telling you both that if you are both willing to wait and try and do it.
Oh, come on, Judge. I mean, it's Northern Michigan. It'll only be 27 months from now before these snow stops.
Then I'm willing to have you come back here in 3 or 4 or 5 months after it's done. If either of you want me to come up with the number, I will do that. So, Mr. Gens, let me ask you that first. Do you want to wait and try to correct it, or do you just want me to rule on it?
I would rather you rule on it and.
Okay. I don't need any specific argument on that. I understand. And in some way, that's a better situation to do.
He wants his money
because, it just takes too long. So what my ruling is going to do is going to give some credit to Mr. Moore for the work that needs to be done, because I'm assuming he's going to have to get somebody else to do it. I suppose he could have you do it, but that's probably not going to be acceptable to either one of you in that regard. So
I told you I would take care of it.
Well, I understand that, but if you want a decision now, it would be based on the fact that he's going to have to get somebody else to do it. He can get you after that if you guys come up with a new contract. So I'm going to give you each one last shot of just a couple of minutes. Anything else you want to say? Mr. Moore, I'll start with you. Anything you want to say?
I have two gentlemen here with me. Would you like to hear from them as witnesses?
No.
What would they have to say?
Well, Gabe was there when Mr. Gens took all the items. Were you there when he brought them back?
Yeah.
He was there when he brought them back also.
Let it go, Walter. Let it go. Okay? We don't care about the items. The items have returned.
And
as long as they've been brought back, I'm looking at it as no harm, no foul.
Yeah. And this all would have never taken place. I would have never stopped payment on the check had he not stolen those things from me. When he takes things from my property that doesn't belong to him,
oh my God. Nobody cares. This is infuriating. Like, the judge is going to knock off $500 or something, I'm guessing, and then we're all done, and then he doesn't have to fix it, and everyone will be happy. We're just having a pissing match because this is I know my people. This is the crap they do for entertainment. They don't even dislike each other. This is Northern Michigan, people.
That's what ticked me off, and that's why I stopped payment on the check. And it was after I stopped payment on the check that we had the rain, and then there was a second reason that's what I told Mr. Gens. I said, number one, you took those things from me that didn't belong to you. Number two, now that it's rained, I have a big bird bath in the middle of the driveway. So that's when I asked him to fix the bird bath, and I would pay him after he brought the material back that he took. The other gentleman that's here with me is Chuck Johnson, and Chuck Gabe works with Chuck, and Chuck was there, and he's seen all that stuff beside the driveway also. It was not junk, and it was
F Chuck. It doesn't matter.
not on a junk trailer. It was all totally away from the junk trailer. Anything that was junk was on the trailer, and this stuff, none of this stuff was on that trailer.
He cannot recover for mileage or anything like that. If things were returned, there's no cause of action for that, and that's not immediately what this case is about. So, Mr. Gens, is there anything you want to say by way of closing?
All I can say.
This is really putting me in mind of the Tarantino movie. I can't remember it. There were two. It was parts 1 and 2. But we have the guy who says, "My name is Chuck, and I like to."
Is he's stretching the truth, but it doesn't matter at this point because, I told him I'd take care of it, but I wanted to be paid. He had no reason to stop payment on the check without at least calling me and talking to me first. And I would have gladly gave the stuff back just like I did. Didn't feel that I was stealing. It was in the junk. And I got pictures of it.
Sure. And I'm going to, like I say, I'm not going to get into that, whether right or wrong. I mean, if you took it, from it was returned to the law looking at it, it's neither a civil nor a criminal matter because it's been returned. And that's, what's there. This case is about a driveway. The value was
Kill Bill. Thank you. Yeah, I had to look it up.
$3,100, but there's some subtraction which the court has to take into account for the gravel. Mr. Moore gives an estimate. Mr. Gent says it wouldn't be necessary, but neither of you probably know for sure. So the court will award. And remember what I'm saying is this is the legal.
Yeah, you can see how I like that movie.
The term is quantum merit, which is really just another way of saying it's the value of the work that was done. Because it sounds like you're both kind of agreeing that it wasn't completed, but obviously what was done was some value. So instead of $3,100, the court is going to award $2,400 plus court costs of $100.20, which makes the total $2,500.20. And the court will make a copy of that judgment. I'm not going to re-argue that. You guys can work out any payment arrangements you want to or anything else. That is the amount of the judgment that the court has awarded.
Could I have that amount again, please?
Pardon?
Could I have that amount again, please?
Sure. And you'll be sent a copy of this. The damages are $2,400 that the court has determined. The court costs, which are out-of-pocket payments, are $100.20. So the total is $2,500.20.
Okay, can I say one thing, please?
No, I don't want to, because then that just gets into a back and forth that's not necessary. I appreciate what both of you had to say. That does conclude this case. Thank you. You're adjourned. Brent, are you still there?
Pure Michigan.
Mr. Vernon, welcome. Mr. Dundon, the court is on the record and calls the matter of Nathan Lilly versus Christina Lilly. This is file 25-11910DO.
Good afternoon, Your Honor. Adam Vernon on behalf of Nathan Lilly.
Good afternoon, Your Honor. Mark Dundon standing in for the attorney of record, Miranda Bailey Quick.
Mr. Dundon, you're in an unfortunate position, and I apologize to you for that, but it's not of your doing, and it's not of my doing. We're not here just for a hearing on a motion to compel. That's one of the things we're here for. And we're not also here for a status conference, although that's one of the things we're here for. We're here because Ms. Bailey Quick failed to appear in court, and I issued a show cause. And the typical way that I handle show causes is I have a direct conversation with the attorneys. And I can't recall a time that I've had to have anything other than a single conversation, and that the attorney isn't apologetic because they double booked or had something going on and they forgot or there was an error and I've set it aside. But I set show causes to have those discussions. You are here attempting to appear on behalf of Ms. Bailey Quick. Were you aware that there was those triumvirate of things, a motion to compel a status conference and an order to show cause?
Yes, Your Honor. I was aware. Ms. Bailey Quick has been off on a medical, but then she was still clearing some stuff up. Again, I can try to text her right now. She's definitely not. There's an evidentiary hearing that she can't not be at today right now, but I know she's not obviously blowing the court off, for lack of a better term. But I do understand this is a delicate situation. What she explained to me is that when she was leaving Harris, the Harris firm, there was an issue with the two.
Mr. Dunn, respectfully, I'm not going to hear your reasoning for why Ms. Bailey Quick wasn't present, or allow the record to stand unchallenged that Ms. Bailey Quick isn't blowing this court off because she apparently has a different court to be in. Because the facts, as they say, are what they are. I have a show cause set. Another court in another county might have an evidentiary hearing set. Ms. Bailey Quick clearly understood that she had a choice. One of her choices was she could appear at an evidentiary hearing. One of her choices was she could appear at this show cause hearing.
Ooh. She chose to make someone cranky. It turns out it was me. So let's not start BSing each other about it, people.
She made her choice. So I understand why you, as an officer of the court and as a colleague of Ms. Bailey Quick's, would attempt to come to her defense. But those are the bare facts. I'm not going to permit that type of action to take place. If I did, I would have those issues in the future. So I'm going to do two things today, perhaps more. First, on the motion to compel answers, I would note that I've had a chance to review the motion to compel answers. I have not received any response. The court has the ability under the court rules to require a written response to any motion. I have no written response, and my requirement, and Ms. Bailey Quick is well aware of this, is that she must file a written response if she wants me to consider any written answer. She's not done so. The court's not considering any written answer, even if it was supplied, because it wasn't supplied to me. And so the motion to compel is granted in its entirety. I'm ordering that the full answers must be delivered to the office of Terry Jaskowski within 14 days of today's date. And I'm signing that on today's date, 12/1/2025. Mr. Dunn, if you didn't know, Mr. Vernon prepared a proposed order. I'm signing that order. And again, I'm just indicating that the answers must be supplied within 14 days of today's date. I'm handing this to the clerk now for filing. In terms of the status, it's not, I'll let you ask any questions in a moment, Mr. Dunn, but I'm going to move methodically through these things before I do. In terms of the status conference, I'm not going to do anything because there's nothing I can do. I don't have the two parties, the two attorneys here. Mr. Vernon and his client are here. They're ready to proceed. Ms. Bailey Quick, again, is not. And I'm not yet foreclosing a chance that I would perhaps make a finding of good cause later, but I'm also indicating that I don't intend to allow to pass an attorney simply skipping out on a show cause.
I think what he's trying to say here is this.
Ma'am, are you a whore? Object.
That sets a terrible standard for the bar. It puts the court in a terrible position. It probably puts you, Mr. Dundon, in a worse position. And I don't intend that feeling for me, for you, for Mr. Lilly, or for Mr. Vernon to have no consequence at all. Even though that's exactly what I intended if Ms. Bailey Quick would have done what I told her and required her to do, which is appear today for a show cause hearing. So while I have not decided ultimately what I'm going to do on the show cause, I'm going to adjourn both the status conference and the show cause. I'm going to order that Ms. Bailey Quick appears in person for the show cause at my next available date. And I'm going to be as explicitly clear as I can. If she's not here on time and in person at the next time I set an order to show cause, I will take the unusual and extreme remedy of issuing a bench warrant for her arrest. Believe me when I say, counsel, Mr. Lilly, that's not something I'm considering lightly, and it's not something I'll do lightly. But enough is enough. Ms. Bailey Quick needs to appear at her hearings, especially when it's a show cause. Mr. Vernon, did you wish to make any record regarding either the motion to compel, the court's treatment of the show cause, or the court's treatment of the status conference?
I would, Your Honor, with regards to the motion to compel, I would ask the court to consider, consistent with our motion, some costs. This is now, this is the third hearing we will have had on the status conference and this motion to compel. We had to draft the motion to compel. We had to appear at this hearing, and I'll have to draft an order to that effect. And now we have to appear at another hearing on the status conference. My client will have had to have attended 2 additional status conferences in addition to the work I did on the motion to compel. In addition to my preparing the order to compel, we would ask the court to consider, I told Mr. Dunn that I was looking for 1.5 hours of work up to today, with the idea that we're going to have another status conference and prepare the order. I would ask the court to consider 1.75 hours of costs that my client has to incur as a result of Ms. Bailey Quick's failure to comply or failure to provide discovery consistent with the court rules.
Mr. Dundon, did you wish to respond to that request?
Your Honor, I kind of don't feel like I'm that well equipped. Usually downstate, I guess what I would have seen would be a email or something to an attorney saying I need this discovery. I'm not sure if that happened, but nonetheless, Mr. Vernon is entitled to his discovery, and I believe the court rules speak for themselves as far as what the
poor Mark. He's just out here catching spears, and he seems like a decent guy too.
remedies are, Your Honor.
Mr. Vernon, I'm inclined to grant some costs because I think it's fair for you to claim error by Ms. Bailey Quick in not responding to the motion, not supplying the information, and then not being here today. By my count, we've been on the record about 10 minutes today. Your estimated time for your motion notwithstanding, I would note that your motion, while it was detailed enough for me to grant you relief, it's also page long. It didn't take you, in my view, very long to put it together. It won't take you very long to put together any order because you already did. I've got it and I've signed it. I'm going to sign it and order these costs. My view is that in totality, between the frustration that you and your client have suffered from Ms. Bailey Quick not being here today, for not being here and needing to reset the motion hearing or the status conference hearing and the order to show cause, it's my view that an hour is a fair amount of compensation. What is your hourly rate in the Lilly matter?
$325, Your Honor.
325?
Yes, Your Honor.
All right. The court is going to award that time $325. I'm going to order it payable to Carrie and Jaskowski PLC and no later than within 14 days, the same as the order with regard to the production of documents. And I'm going to
Very reasonable.
order further again that I'm going to set this for a follow-up.
Both the rate and the ruling, everything. That's enough. The judge is trying to tamp it down. It's just really, you got to knock this crap off.
Status conference in order to show cause with Ms. Bailey Quick in person. Mr. Vernon, because I know you're local to Grayland, you're welcome to be in person as well. I don't require that, but if you wanted to be in person, sometimes that's a better way for all of us to proceed, but I'll leave that to you. Did you have any further questions, Mr. Dundon, or for anything further you want to state for the record since we're all here?
No, thank you, Judge. I just want to, so the court's you're scheduling the next date, Judge, but it's not exactly sure when.
Correct. I'm going to set it. I'm going to have my staff set it. Ms. Bailey Quick will get a notice and she's required to be there in person.
Yes, sir.
And hopefully you can communicate to Ms. Bailey Quick the tone and tenor of this hearing as well, because this is not something that I think any one of us should have to deal with. And I hope Ms. Bailey Quick is aware of that.
I will definitely, Judge.
Mr. Vernon, anything else?
The court wants two separate orders, one order on the costs and one order on the motion to compel, or is it all in one order? Okay.
I just hand wrote in from the order that you prepared. I have it all in the same order.
Oh, okay.
Yep. So the court already has the order.
Okay.
And I would note that your proposed order, I'm glad the clerk just saw that. It said Christina Lilly shall pay the assessed costs. That's wrong. Miranda, counsel for Christina Lilly. So counsel, I'm writing in counsel for defendant shall pay the assessed cost of $325. Again, my view is that the problem that amounted to the need for sanctions, in my estimation, was not so much Ms. Lilly not providing answers as Ms. Bailey Quick not being here today in order for the court to conduct business and otherwise have a contested hearing.
Thank you for the clarification, Judge. I have no other questions.
Thank you, counsel.
Thank you, Your Honor.
Good times. Also very reasonable, though. I mean, that's really annoying. I've seen that a few times. The judge went out of his way. He wants something to happen. Both attorneys were reasonable. The one attorney that is there, I mean, he's trying to help, but like her conduct is bad. And the other attorney didn't ask for too much. And the judge didn't give too much, but enough that it's a smack on the wrist. And it's a signal that if you keep going, it'll get worse. I don't know. Those were two reasonable hearings in a row, ultimately, but they were still fun to watch. Thank y'all for coming out. I appreciate it. I just had so much good material that I had to do a Vlog Talk overflow stream. I consider that a good day. Thanks for coming out.